Annenberg Media.
With additional support from Equicor Equitable HCA Corporation, the Good Listening Employee Benefits Company.
We do not all start life on an even playing field. But the rules are that we all play it by the rules of honesty and ethics.
Before I took that case, I had to agree that I would do anything ethical to defend that man.
So I'm going to just do the best I can. Is it imperfect? You bet. Is it awful? Well, maybe so.
Isn't there a point in a civilized society where one man has to be willing to step outside the system and say, no, I cannot do this because it's wrong?
I think we're at that point, which is nice in the sense, ethically, where we don't have the rules to protect us. We have to agonize with ourselves and our conscience.
The truth, the whole truth, and nothing but the truth. More and more, we seem to bring our grievances, large and small, to the courtroom, seeking something that corresponds to our sense of justice. The truth, the ancient oath tells us, is the essential ethic of that process. But the professional codes for lawyers demand zealous advocacy, and as we shall see, such zeal may not always lead to a sense and a search for truth. The justice that lawyers are trained to seek is whatever is right for their clients. As a much-quoted opinion put it, an advocate knows but one person in all the world, and that person is his client. At times, the gamesmanship and the strategies in a trial seem to be at odds with the ethical codes we all accept in all other aspects of our lives. Does the adversary system allow, in fact, even demand, that lawyers act in a way that for the rest of us would be considered amoral or even immoral? In our hypothetical case study, our moderator is Charles Nesson.
Mr. Abrams, let me introduce myself. I'm Hiram Powers. I'm the chief executive of Hot Products. We make space heaters. Particularly, we make the Hot Boy. It's a kind of a low-end, cheaper space heater. Very wide distribution. You and I are having lunch, and you're the counsel to this company. Can I talk to you in confidence?
Sure.
Sure. Well, something I wanted to run past you. I've gotten a memo from Nellie Barnes, who's a safety engineer, has been with me ever since I got started in this business. I call her Nervous Nellie, to tell you the truth. That, she's worried about the Hot Boy. Apparently, there have been a few fires, but, you know, there are always fires with space heaters. And she's worried that under some circumstances, the heater tips over, and the shutoff doesn't work, and could be responsible for a fire. And I've looked at it and considered it and figured what it would cost to change the product and put an emergency shutoff on it. And the fact is that it would price our product right out of the range that we're in right now, completely change our market structure. And I've decided that it just isn't clear enough that we've got a problem to shift the product, and that's my decision. But I wanted to run it past you to see if there are any problems.
Well, there could be. I think you really ought to check up on it because if anything does happen, if anybody does get hurt, first of all, the company will be liable, and the liability could be augmented by the fact that you're now on some sort of notice from Nellie Barnes.
Well, Nellie, by the way, Nellie's been with me for a long time, and she knew this was delicate. So she brought this into me by hand, eyes only. This is the only copy, boss, only copy.
Yeah.
So I don't think we got a problem that way.
I wouldn't count too much on that. Xerox machines are around, and but if anything ever happened, she'd have to testify. You'd have to testify.
Mr. Neal, you got any problem with my business decision there?
Sure do. You may get some zealous prosecutor who wants to prosecute you criminally, too, for some sort of reckless conduct. It's a very dangerous thing to go ahead. And I would recommend that you stop right now and determine whether this space heater is dangerous to the users or not, and not go ahead. And I would even perhaps consider a recall.
Let me just.
And I've now lost my job as general counsel, haven't I?
Yeah, well, I want to know whether you, as my counsel, think that it's your place to tell me that I'm wrong.
Yes, I think it's my place to tell you that that's bad judgment, and you've also put me on the spot because I don't know what my ethical responsibilities are now. I think my primary responsibility as board of directors, I think, now that I think about it, and now I think about the danger of the company in the continuation of the marketing of this hot boy heater, I think I've got to go to board of directors and tell the real bosses of the corporation just exactly where we are.
I think it's incredible that Mr. Neal's quite so worried so soon. We've got one memo. I want my job.
You don't think he's going to last too long, do you? Miss Birnbaum, you know, I've always made my toughest decisions just by myself. You know, I sit down. I used to do it just write out longhand. Pros on one side, cons on the other. Now I've got this new computer, and I do it on my computer. I show you a memorandum that I've written, my notes, just me to me. And there it's all laid out. Nellie's description of the difficulties, my estimate of how many fires this might cause, maybe 40 fires a year, if what she says is true, which may not be true at all. Some people might get killed, maybe 6. An estimate of how much it would cost to settle those lawsuits, maybe $200,000 apiece. A judgment about how much it would cost to reposition the product or recall the product out of sight. And my conclusion, better to study this problem further, keep producing, and after all, I say at the bottom of the memo, the kind of people that use these hot boys, cheap space heaters, they're not really into lawsuits that much. They're much more interested in tacos and watermelons.
You got a smoking gun document. That's the kind of document that, if in a civil litigation is discovered, as Mr. Neal knows, the kind of document that leads to punitive damages in civil lawsuits as well as compensatory damages if you don't do the right things from that point forward.
Well, this is only my own little thing on the PC.
That's right.
I guess I should just get rid of it, shouldn't I?
I'm not so sure you should get rid of it. You shouldn't really be destroying it, although the whole question of PCs and written documents and what's on computers becomes a very difficult kind of...
These are just my notes to myself.
That's right.
What happens to me if I just erase it?
Well, documents that get destroyed or lost are documents that are even worse than documents that are found very often, because the inferences that juries make, and probably accurately, are that if the document has been destroyed, it says terrible things, even much worse things than you have.
Mr. Abrams, I want your counsel here. Now, how about this other document? How about the just...
Notes are, I think, a different thing. They're, I mean, if they can fairly be viewed as your notes to yourself, unless you have a practice of always keeping all your notes, and particularly if you're talking about PC, and if you do override things that you've written to yourself as a general matter, there I think that it's a lot closer call. And first of all, I'd advise you, and I hope I would have earlier, not to do memos like that, please. Not to write things like that. And if you have that tendency, to always go over them and write your next thoughts and go over them.
Mr. Gillers, is there anything illegal if I just go bloop and the memo's gone? Have I done anything illegal?
Not in any jurisdiction I know of.
Not in any jurisdiction you know of?
Not at this point. And if it's not illegal,
and it's tactically wise to destroy it and then deal with the fact that you've destroyed a memo, perhaps pursuant to an official memo destruction policy, then they'll deal with that tactically. But it's not their job to help your future adversary down the line.
Wait, I have a problem. That's a distinction without a... What if he pushes the button and it prints out and he then destroys the printed copy? No problem?
He can take that memo and have a ritual of destruction over it.
Selectively.
And
selective destruction.
Right there at lunch, we take it, we go, and like...
No one says he can't. It's purely tactical at this point. Floyd and Sheila and Jim are perfectly within their rights to say, get rid of it, Charlie. We'll deal with the fact that it doesn't exist if they discovered it ever did exist. Later, right now, you are legally permitted to get rid of it. We are ethically permitted to allow you to get rid of it. Get rid of it. They'll never think to ask the question about tacos and watermelon.
That's wrong. That is absolutely
That's incredible.
wrong.
That's wrong. Judge Scalia, what do you say?
I think the statement of the law that's just been made is correct. Sounds right to me. I don't know of any jurisdiction.
You mean that incredible wrong statement we just made earlier? Now, Mr. Gillers, just educate me a little further on the legalities here. Does it ever become illegal for me to destroy a document?
Sure, but we've made a decision that it doesn't become illegal until much later down the road, when it's subpoenaed, when it's noticed in discovery, perhaps once an action has begun, perhaps the day before you know an action is about to begin.
When somebody asks for it with a legal request, like a subpoena, then I can't mess around with it.
Virtually anywhere, then, you can't mess around with it.
But before that, I can do it.
Before that, you can create them and destroy them, as you will.
Well,
now,
Mr.
I'm
not sure
Cochette,
all the way before. I mean, if there's a suit pending, and even though nothing's been subpoenaed yet, I think it's questionable.
Justice Scalia is right. At this point...
Hey, very wise. Very wise.
I just wanted to return the favor.
Can you...
At this
Can you
point...
find 4 others like him?
The question, Judge, is can he find 4 others like you? Here's what happens. A few months after this conversation, Mr. Chesley, let me take you back a few years, all right? Right out of law school. You're sitting there in your office and you hear sirens. You look out the window, fire engines. You follow it, and you see that there's a fire in an apartment, tenement house. Are you interested? Would you go to the fire?
No.
You wouldn't?
Never did it since 1960 and wouldn't do it today.
Maybe you're not my man. Mr. Cochette, would you go to the fire?
I wouldn't go to the fire.
How about just out of interest?
I might go out of interest, of course. Get to the bottom line. Would I chase a client down the street?
I like to get there slowly, all right? You go to the fire and you see a fellow clearly distraught over by an ambulance. You ask a question, it turns out this man lived in an apartment with his young daughter. The fire, daughter has been killed, apparently, going off in the ambulance. Father's grieving there. In fact, you overhear one of the firemen say something about a space heater. Would you consider going up and talking to the father?
Not even a question.
Why not?
I'd go up to him and I'd talk to him and I'd say to him specifically,
Oh,
Sir,
you would go up and talk
absolutely.
to him.
I'm now there. You put me on the scene.
Yeah.
I'm on the scene. I hear a fireman talking about a space heater that caused that fire.
Yeah.
I'd go right up to that father and I'd say, Sir, you better investigate what caused that fire, and you better make sure you get someone who's good and competent and understands the problem. Absolutely, without a question.
Would you give me your card?
That's, you know, I don't think so, no.
Yes, you would.
No, I wouldn't. No. I might tell him my name. I don't know that I'd give him a card. I'd tell him my name of 3 or 4 other lawyers in my firm that happen to handle these excellent.
Telephone number.
No, I wouldn't do that. No. But I'd certainly make him aware, and I think that's, you know, this whole fallacy of running after cases. I agree with the wholesale shopping is wrong, but the fact situation that you present, yes, sir.
Who's going to pay for you to represent that father?
I'm going to handle it on a contingent fee arrangement.
And what does that mean to the father?
What does it mean? It means it opens the doors to the courthouse if someone that otherwise couldn't afford to hire a lawyer like Sheila or Floyd or someone else, they couldn't pay hourly wages, so I will take it on a contingency.
And you justify that as a kind of like public service, opening the courthouse.
Not only do I justify it, I'm proud of it.
These plaintiffs' lawyers bring their lawsuit, all right? And we're looking at discovery now. I'm going to be deposed. Ms. Birnbaum, deposition's coming up very shortly. You got any advice for me as to how I should prepare for this deposition?
Absolutely. I would tell you to tell the truth, to not volunteer and expand on answers, but answer the question directly that's being given to you, and to only answer if you're sure that you know the answer. You shouldn't guess at things. If you don't know something,
Well,
you can tell somebody you don't remember or you don't know something.
You would never tell me to lie, would you?
Absolutely not.
But how about I don't remember? Mr. Neal, how about I don't remember?
Well, if you do remember, that's a lie as much as saying it didn't happen. So I think that you would remember, and I think you now have to go over that.
Wait one second, would you?
All right.
I'm telling you, I don't remember.
Sure.
Are you going to remind me? Are you going to say to me, oh, come on, high powers, you remember perfectly well. I remember that document. Let me remind you what it said. Are you going to tell me that?
You're into this, and I think that at some point in there, I would have to make a judgment whether you remember and therefore are going to perjure yourself, or you truly don't remember. I don't know how we get into, I don't remember. It's like the guy, I forgot between January and February. I probably would have to say, look, you must not perjure yourself. If you're still going to perjure yourself, and my judgment is, I've made that judgment, I would have to, again, withdraw. I've lost, this is my second position I've lost in this forum, but I'd have to do it. If I'm an honest, ethical counsel, I would have to withdraw. Now, the more difficult question comes in is, what if I then learn, after I've withdrawn, that you did go in and perjure yourself? What do I do then about ameliorating, even eliminating that fraud on the court? That's very difficult.
I'm looking for a lawyer who's going to help me here.
Right.
Mr. Abrams, are you going to help me here? I'm going into a deposition. I don't want to just spill my guts to him.
You don't have to spill your guts to him. You
I wanna-
you have to tell the truth, though.
Yes, that I'm going to do.
And tell the truth means it.
And
Means-
answer the questions
Means answer the questions
as
that he
narrowly
asks
as
you.
possible, though, right?
Within reason.
Within reason.
But generally narrowly, yes.
Suppose they ask me, Mr. Powers, are there any memos written in response to the Nellie memorandum? I don't want to tell them. Can you do anything to help me out in that situation? Or do I just have to say, yes, yes, here it is?
If you wrote a memo, the answer to the question is yes, I wrote a memo.
I don't really consider it a memorandum. I consider
what
it
is
just,
it?
Okay, it was like personal notes.
Oh, that document. Look, I think there it really does depend how the question can be fairly understood.
Could I fairly understand it as asking for memoranda, not for personal notes? Ms. Birnbaum,
That's a fine cut, and I think if you literally took the word memo to mean something other than notes, you could say, I didn't write a memo.
hey,
That's the lawyer you're
Hey.
looking for.
I wrote notes.
hey.
And part of the adversary...
I don't have to come forward and say,
But I
didn't write any memos, but I did write some notes.
But I don't have to come into the deposition and say to Stan Chesley, hey, wait a minute, I have something I'm hiding either, or I have written, and this is what really happened, or this is what happened at all.
He's got to find that
His job is to
out.
ask questions.
Now, I've got a fair interpretation. It's personal notes, not a memoranda. Can I say in response to the question, hey, no memoranda?
I don't think so, and I would strongly urge you not to do that.
Would
Now,
you
you're not
consider,
gonna-
as the lawyer, asking a clarifying question? Such as, you mean memoranda sent to other people in the company or received from other people in the company?
That's possible.
Yeah, that's what I mean.
I would.
No.
Yes, if I could get him to say in some fashion on the record that he wants something which we don't have, then the answer is we don't have it. And if I can get him to clarify his request in a way which cuts out notes to myself or doodles on a piece of paper or things I said to people other than Nellie, for example, It depends what the question is and how the question can be fairly understood.
But isn't that all gamesmanship?
Yes, let me give you an example.
Oh, you've never heard of gamesmanship? I'm shocked.
Not on this side of the table.
Touche.
Mr. Cochette, Mr. Cochette, you're representing someone in an intersection accident case. This is a hypothetical. Person's involved in an automobile accident. They're supposed to wear their prescription glasses. The client comes to you and says, I wasn't wearing my prescription glasses. I was wearing my sunglasses. And you take that client into a deposition, and Mr. Abrams asks the client, sir, were you wearing your glasses at the time of the accident? Can the client say yes?
Surely.
No problem.
Not with the question as framed, and yes. The answer is yes.
Isn't that gamesmanship?
That's not gamesmanship, no, because I haven't objected. I haven't objected to the question yet, and I assume you're going to ask a follow-up question.
No. No, that's it. Hey, were you wearing your glasses?
Well.
And she says, yes, she was wearing
Yes,
glasses.
I was wearing my glasses.
She was
Of course, they were my sunglasses. They were not my
now
prescription
you know what?
glasses.
Then I'll tell you what. If you're getting to the point where it's a material fact in that accident, and I assume that's where you're going,
hey,
I'm going to have a
glasses.
tough problem with that.
Judge Marriage, are we talking the real world with these guys here?
I'm afraid we are, but I'm not very proud of it. It seems to me that we're forgetting the oath that you take in the first place, and that is to tell the truth, the whole truth. If he asked you for glasses, you know what he meant. Prescription glasses, the glasses you usually wear, and you ought to tell him.
Mr. Gillers, what is the lawyer's obligation?
I think both sides in all kinds of cases carefully weigh the exact language that the other side uses. They become literary critics, and if it's notes and not a memo, it doesn't count. And if it's in reaction to the memo and not in response, the word you used, because response means you send it back, it doesn't count. And if glasses is a generic term that includes non-prescription as well as prescription glasses, it doesn't count. And if the other side did not frame the question more particularly, we play blame the victim. That's what we do. We have done it for generations, and we do it today.
And indeed, that's why we hire lawyers. If anybody can ask any sort of an ill-framed question and get the whole truth, you wouldn't need lawyers.
Yeah, but in all candor, Justice, I believe that in the framing of questions, the way the questions are going to be framed, the lawyers are smart enough that they're going to include memorandums, writings, dribble, or whatever.
Exactly.
And glasses are going to include prescription and so forth. So I don't think you're going to have a whole case is going to rise and fall on the semantics of a question.
Except it does, and you're smart enough to say any kind of writing in response to or reaction to or caused by Nervous Nellie's memo. But some lawyers won't say that. Oh. And when those lawyers don't say that, we blame them for not saying it, and we say, hooray, now we can answer the question in the narrowest possible, innocent way. That's what we do. That's what plaintiffs' lawyers do, and that's what defense lawyers do.
Mr. Neal?
That's what they get paid for doing.
It happens that this is supposed to be ethics and law, and I think one of the things that's striking me here is, one, most of you talk inside the house entirely as lawyers. Ethics gets into it only insofar as it's identical with utilitarianism, and you put your finger on that when you talked about practical. I'm not saying utilitarianism is not an ethical viewpoint, but mostly it will turn out to be a cost-benefit analysis. Now, that's not the only ethical tradition that we have, and if you're telling me that, in effect, what you call ethics and the law is simply utilitarianism or a cost-benefit analysis, how do you plug someone's death into cost-benefit analysis? How do you plug treating somebody as a thing into cost-benefit analysis? You said before, very early on, when the question of people dying from this damn heater was brought up, that you were ready to pay the price. How are you paying the price of death? How would you go about doing it?
Mr. Gillis, what do you say to this man?
Immanuel Kant would have made a lousy lawyer, but a great judge.
All right, let's take it one step further. We go through the discovery phase of this business, and Hiram Powers doesn't recall the details of his PC memorandum. He admits that he took a few notes, maybe, but destroyed them as he usually does. And it doesn't come to much as an issue. Towards the end of the trial, into your office, Mr. Chesley, comes Tess Trueheart. Tess used to be the secretary to Hiram Powers. She says, I was going through files. I came across one of the boss's floppy disks. I plugged it into the machine, and there was this decision memorandum about the hot boy. And I remember it in detail, and she recites it right down to the taco and watermelon line at the bottom. Now, she hasn't got a copy of it. She's just got it from memory. Are you interested in her?
Absolutely.
What are you going to do with her?
I'm going to ask her if she'd be willing to testify. I'm going to ask if I can either, if we're still in the plaintiff's case, you have to list all your witnesses. I'm going to go to the judge and ask if we can amend our list, tell them exactly what happened together with opposing counsel. Or in the alternative, if it's already been Powers has testified as a defendant, I'm going to ask that she come in as a rebuttal witness. I don't know if we can get past the hearsay, but I think we can under some of the exceptions to the hearsay rule.
Mr. Neal, Tess takes the stand and describes this memo. It's devastating. Are you interested in Tess's background?
Oh, I've got to destroy Tess, or my client is destroyed. And so I must go out to destroy Tess.
You'd be willing to put an investigator on Tess to see who she was?
Yes, I would try to find out what I would, you know, this is really
Here's what your discreet investigator finds out.
Okay.
In fact, Tess changed her name 5 years ago. The reason she changed her name is that she, in fact, had quite a past. She'd had a big drug problem. She'd spent a serious psychiatric problem, spent some time in a mental institution, had an extraordinarily messy divorce, a lot of stuff in it. And she just turned over a new leaf, changed her name, started this new life, and she was in pretty good shape. Are you going to use that?
Do I know that there was such a memorandum and that you prepared it and that she's telling the absolute truth?
Mr. Neal, you remember that lunch where Hiram passed it to you?
Well, you're going to make me play the heavy again. I was hoping you'd say I didn't know maybe about the
When Tess testified at court, when she recalled that document, you remembered word for word, and she had it just right.
I know that she's telling the absolute truth. I know it's in my power to make her appear to be a liar.
You got it.
Right. It's the most difficult decision, I think, that a trial lawyer faces. I think I would come down, God forgive me, making her look like a liar.
Cross-examine me. Here I am. I'm Tess.
I'd say...
You're a witness.
Oh, your name is Tess Trueheart, right?
Yes,
How long's it been Tess Trueheart, Tess? Were you ever known as anything else, Tess?
Judge Marriage, do I have to answer that question?
I think you do.
Judge Patel, do I have to answer that question?
Well, first of all, it's not going to all call her Tess in my courtroom. But once we get... once we get
Well, I know her very well.
Once we get past that, we're going to have an in-camera session with counsel and find out exactly what he's after and what he's got and whether or not it's relevant and whether he's going to be permitted to go into it.
Let's go a little further, Mr. Neal. Where are you going to go from here?
Oh, I'd say...
Yes, I changed my name 5 years ago.
All right. Miss Trueheart, you said you saw this mythical document you've been talking about up here on the stand. Have you ever had any occasions in the past to have auditory hallucinations or to see things that didn't exist? In fact, Miss Trueheart, have you ever been institutionalized? And on that line, I'd set it up hopefully a little better than that, but I would bring out the fact that in the past she'd been under care of a psychiatrist, that she'd been seeing things that didn't exist, and I'd say, aha, and sit down. I'm going to be a very popular man in this group around here.
There was one word that just hit me as it went by.
Uh-huh.
No, mythical was the word.
Oh, well.
Mythical.
I might get called down for characterizing that. That's testifying a little bit, but I'd still try. I'd say this mythical document. And then the judge would
even though you know that document was no myth whatsoever?
And an adversary society puts us in all these ethical dilemmas at all times, because the whole concept is that that man is going to do his job, I'm going to do my job, and out of the clash of these jobs will come the truth and justice.
Mr. Neal.
I would have to destroy Tess. I would have to do it even though I guess I knew that, because I'm using the truth.
Tess?
The truth is she's changed her name. The truth is that she's been institutionalized, having auditory hallucinations and seeing things that didn't exist. I'm putting out the truth. There is that person. Now, my goal, I guess you'd say, is to deceive the jury. But I think that's permitted in our system.
If what you're telling us you have to do is necessitated by the system, we have to take another look at the system. It's not a matter of being a starry-eyed fool. It's a matter of trying to get some critical distance.
I'm not at all sure. I'm not at all sure we shouldn't take a new look at the adversary system.
Well, but look, all I ever read when I hear a justification, basically two things. This stuff about the truth comes out through conflict. I have never seen a lively debate where people are at each other's throats that ever resulted in any truth. Mostly it results in an exacerbation of the issue and maybe a clearer definition of it.
Judge Patel, you mentioned before that you would consider whether you'd allow Mr. Neal to do this. Having heard what Mr. Neal is up to, are you going to allow it?
No, not based upon what I've heard so far. I'm not going to let him use the term mythical, for example. I have the power to correct what I may believe is an effort on both sides to deceive the jury and do more damage to him as a result of that kind of question than that kind of question would suggest.
The question is, are you going to let him go after the witness on her name change, her psychiatric history, her drug involvement?
It depends upon how proximate it is to the time of her testimony, to the time when she went to work for this company. If there's been a lengthy history of her having had no such problems, I'm not going to allow him to go into it.
Judge Marriage?
The short answer, I think, is it relevant to her credibility? These are tough questions, as you know. I don't think there are any easy answers, but we've used the adversary system, I think, very well for a long, long time. There may be, as Dr. Smith suggests, maybe we ought to look at it again. But being absolutely practical, and it's not going to make me very popular with the members of the bar, lawyers are not always looking for the truth in a case. But if they stay within the rules, it's worked for a long time. Bothers me, but not so much. I wouldn't go as far as Judge Patel. I'm not going to make those kind of decisions. We have a jury there. They're going to judge the credibility of the witness, and I think Mr. Neal has the right to do what he's doing.
Justice Scalia?
I agree.
Would you mind saying that again, sir?
I agree. I think the problem is the adversary system. If you want to have the adversary system, this result follows. Now, Professor Smith may say scrap the adversary system, but you better look at what the alternative is. The adversary system has been described, not too unrealistically, as based upon the premise that if you take two photographs, one focused too far and the other one focused too near, superimpose them upon another, one upon the other, you'll get a sharp image. That isn't always true. But that is certainly an accurate description of what the system consists of.
Even though the people inside the system are working as hard as they can to produce a result which they know to be untrue?
They are working as hard as they can to produce the true evidence that is most favorable to their case. And the other side is working as hard as possible to produce the true evidence. Once it becomes false, you're out of the system. The true evidence that is most favorable for the other side. And let the jury pick between the two truths.
But I would respectfully dissent that all too often it happens that there's not an effort to obtain a sharper image, but to obfuscate in the hopes of deceiving the jury or misleading them just a little bit so that they will find in favor of your client.
Mr. Gillers.
The problem that Judge Patel has is that she doesn't know if the witness is telling the truth, and Mr. Neal is not going to tell her, and she can't ask him. He knows that as a result of a privileged communication.
Can't you say to Mr. Neal, at least you have an ethical obligation not to consciously lead the system to an untruth?
Listen, for better or worse, and it may be worse, and we can all vote to change it tomorrow, but Mr. Neal has the opposite ethical obligation. As Justice Scalia correctly says, his obligation is to introduce that truth that helps him and encourage the jury to disbelieve what he knows to be the truth if it helps the other side. And the other side is going to do the same thing. And the truth that we finally get, the so-called courtroom truth, may be false, but it's true for the purposes of our justice system. Sounds odd? It is odd. That's the system we've been living with for hundreds of years.
Here's what happens. The case comes almost to conclusion. The evidence closes. You've had arguments to the jury. It's a Friday afternoon. Mr. Neal, you've been through a tough one here. Monday morning, the case is going to go to the jury with the judge's instructions. You're sitting having a Jack Daniels, and a young associate of yours comes up to you, ashen-faced, with a floppy disk in his hand. Says, boss, I was going through the files, and I found this floppy. And when I put it in the machine and brought it up, there was a file on it called Nellie, and there was the document. What do you do?
Well, I think I have to ask you some questions on that. Have I denied the floppy existed?
No. Well.
See,
Well.
Production of documents.
Yeah.
Yeah. I guess Hiram Powers has said there's no record of it. I destroyed it.
Yeah. Okay, although everybody thinks I'm a scalawag, I go to the limits of the Code of Professional Responsibility. The Code of Professional Responsibility would require me to produce that for the other side now.
All right, that's Friday afternoon.
Since I have denied it existed, I now know that it does exist. I have to produce it.
Friday afternoon, judge has gone fishing. Nothing happened until
I try
Monday.
to settle that case first, maybe.
There's a phone call. Surprise phone call.
Mr. Cooper, what do you think?
I'd settle it.
You'd settle it, wouldn't you?
Yes, I would.
That document, if it comes out, it's murder for the company, isn't it?
Absolutely.
So what do you say, Mr. Neal? Will you give Chesley a call there? And he's been asking for $1 million to settle the case. Would you consider calling him and saying, Chesley, did a fine job. I'm ready to go for your $1 million.
No, I think I would have to tell Mr. Chesley before I settled. I could not settle without disclosing that document to him. I'd have to do it.
Ms. Birnbaum, can we settle the case?
I think we could settle the case. I don't think it makes a difference whether you settle the case for $1 million or you haggle a little and settle for less than $1 million, because obviously the plaintiff's lawyer may still have concerns about the case as well.
If you settle this case,
offer, even if you don't haggle, the settlement offer has been based upon the misinformation that you gave him. So I'm not sure that makes the difference.
You must reveal the document.
I think you must.
All right, here's what happens. You reveal the document. And the offer, of course, goes up. I mean, it was $1 million before, now it's $3 million. And you're ready to pay $3 million. But you want to control the future of that document. Can you do it, Ms. Birnbaum?
You want a confidentiality agreement. You're going to settle it for $3 million, but you want to get all your documents back from the lawsuit as part of the settlement. And again, this is something that goes on very often in civil litigation, especially in the products liability area. As part and parcel of the settlement, the defendant asks for the confidential or the documents back that have been given in the lawsuit. And very often, most times, there is an agreement between the plaintiff and the defendant to do that. There may already have been a protective order in the case requiring that.
My problem is that while I would like not to have it confidential, and while I would like not to return the documents, my ethical duty is to my client. And if I can maximize recovery to my client, that is who I work for. And therefore, if the condition of settlement with that case has to do with returning those documents, then I believe that I have an ethical duty to accept the settlement so as to maximize his recovery. For example, if I say, no, I will not give you back the documents, and they say, well, fine, we withdraw the settlement, you get nothing, the verdict comes in for for the defendant against the plaintiff, I have absolutely violated my duty to my client. The problem that we are having now is not only so much the confidentiality as to who gets the documents, there's an attempt to prevent the plaintiff from continuing to do future litigation against Hot Boy, and I resent that because I think that's unethical.
Well, that's not...
Plaintiff's lawyer. In other words, part of the consideration is you're now to have a lobotomy, Chesley, and you're not allowed to in any way ever represent anybody against Hot Boy.
All right, so
I won't do that. That's unethical.
Let me parse this out just a step here.
Well, why not charge him $3 million more? Can you sell him the disc in effect?
That's the question.
Say, I was willing to settle for $3 million, but if you want the disc kept confidential.
I thought that's how we got it from $1 million to $3 million.
Okay. No, I thought it went up to 3 simply because the case was a lot stronger now, and you know, the uncertainties of the case went into the million. Are you going to hold them up for $3 million for the disc? Is that ethical?
I don't believe it is. I believe that we owe a duty to go to the court, Sheila and I, go to the court and tell them the facts and let the court make the hard decision on the confidentiality of the document. My concern, though, is while I will return the documents to them, there will also be a letter that says I am hereby returning them with the understanding that they will not be destroyed and that they may be used for other future claimants, irrespective of whether I represent those people or not.
No deal. Won't make that deal.
Then I'll go to the court on that one.
No deal.
Then I'll go to
and
the
they're
court.
not going to pay their $6 million to you.
Oh, they will if it's confidential and they get their document back.
Yeah, if.
And I'm willing to
But not unless you give them that agreement.
I give them back the document, but I'm not going to give them the right to destroy the document now relative to future litigation. I don't have that duty.
Why is that your business?
It is my business.
Why? You have your client.
No, I have my client, and my client's got the money because I believe that...
Your client hasn't got the money until you make this deal.
Oh, I'll go to the court on that one because I'm giving the defendant everything that they're legally entitled to have, which is confidentiality and their document back. And I believe that a court will enforce what I am suggesting.
Impose a settlement? How can a court impose a settlement? They can't do that.
Impose a settlement.
They're entitled not to make the settlement if they want.
They're entitled to destroy the document now?
If it's not illegal, why not?
If it's not illegal, if it's illegal, you're making your client pay for so that future clients can recover. Is that
I would not jeopardize the settlement, but at the same time,
you just did.
I don't believe that they. No, I said I'm going to. Dear Ms. Birnbaum, I'm returning the document, I'm returning the floppy disk, but I am urging you and stating to you that this disk should not be destroyed so that it may be used for future litigation.
Does your duty to keep the confidence depend upon them not destroying it?
I can't, once they own it.
Mr. Abrams?
I think there's another player here, too, that we haven't mentioned enough. The court has got to decide whether to enter this protective order, and the court should consider, in deciding whether to enter it, Mr. Maynard over here, who is the surrogate, as it were, for the public.
Well, let's see how Judge Marriage takes that one. Judge Marriage, here's the way it comes up to you. Ms. Birnbaum comes in and has worked out a settlement arrangement with plaintiff's counsel. But the agreement requires that all documents be returned, that the plaintiff treat as confidential the existence of this floppy disk, and that the records are sealed on it. And with that, the case will go away.
I really don't have any problem with that. Well, the only problem would be they'd get hell for waiting so long to settle it. That's neither here nor there. It's private litigation. I really wouldn't have any problem with that at all. I'd enter the order.
But unfortunately, one of the problems of the public interest in knowing how these matters are resolved is frequently compromised by settlements in which part of the understanding of both parties is that all of the documents that have been identified as confidential in the litigation will be destroyed upon the settlement. And history, as well as news, suffers as a result of that practice. We have here in California companies who exist solely for the purpose of making certain that confidential documents at the conclusion of litigation are not just burned, but burned and then boiled in sulfuric acid and then turned into something that can be undescribable. You know what I'm talking about. And then they bury it. And I think that's quite appropriate within the framework of what we think has happened here. And I think it's a troublesome aspect of our system is that there is, I heard Judge Merridge use the term, well, it's private litigation. Well, I'm not so sure that after the taxpayers of this nation have paid what they pay for the cost of litigation, that indeed it is fair to construe the work product of that event as being private. But I'm afraid that if the issue here is that a company had a long-standing practice of producing a product that was harmful to the community, and particularly to the most vulnerable sector of the community, and where the chief executive officer had made a decision of his own as to the value of the victims' lives without, of course, having consulted the victims as to whether they agree on the price, it seems to me that there is a great public interest at stake here, and unfortunately, in many such instances, the documentation and the support for what happened do indeed disappear.
Mr. Cooper, what's going to happen to this floppy disk after you paid $6 million to get it back?
Well, first I'm going to fire you for writing it in the first place and for having the bad judgment of proceeding in the resolution of the Nervous Nellie memo in that way. I will give Mr. Neal a raise.
You like the way he's handled it?
I like the way he's handled it. He should have forced the issue initially so that we should have settled it at the beginning, while in the meantime we were correcting the product. And I think the outcome justifies that kind of a procedure.
Well, let's face it. I mean, the product may still be perfectly good. We've just got one little lawsuit here, equivocal facts. It's true, I popped off in this memo in a way that I'll never get wrong again.
You won't have a chance.
Mr. Banks?
The fact is, the product may not be defective. You may have been fired, and the product may be working well. It's just your bad judgment. And yet the circumstances are such that you know you're going to lose big in this case because you were, as a principal, involved in it. I don't see the public interest in that. I really don't understand that if the assumption is then it's only one bad product and one big lawsuit, why that should be a matter of public record. The corporation has fixed its problem, and it has to fix its problem. I mean, there are other forces that make it fix its problem, if there is one.
And if it becomes well known that a plaintiff recovered $6 million, you know you're going to get flooded with lawsuits.
And it will become well known.
Judge Patel, are you going to agree to the confidentiality of...
They may stipulate or agree to whatever they want to do between themselves, but I will not sign the order. This is not private litigation in my view, but litigation between private parties in a public forum. And I don't see my job as the presiding over a court in that public forum to allow them to enter into secret agreements. If they want to do that on their own and stipulate to it, that's fine. But I won't sign, put my imprimatur on it. There's another problem. What I may later be asked to enforce that. It's an order of the court. Someone violates it, they come in and they ask for contempt against a certain person. You know, half the plaintiff's bar may know about it. And how am I supposed to enforce that order? It's essentially unenforceable. So no, I will not sign it.
What happens if the settlement turns on your agreeing to it?
So be it.
You won't...
I will not sign it.
And if the plaintiff winds up coming up with nothing and says, if only Patel had signed it, I would have $6 million today?
It goes to trial before the jury. The jury decides. That's what the system is about. It's not my job to look out for the interest of either side, but for the system and the integrity of it as a whole.
Mr. Maynard, are you going to find out how much this case settles for?
If our reporter covering that courthouse, Judge Patel's courthouse, does not have within 24 hours the details of that settlement, I'll put somebody else on that beat.
Who's your reporter going to find it out from?
From all the blabbermouths that exist in the legal community, which is second only to journalism in the degree to which there are no secrets. One of the facts of life with which we live is that our open society is such that you can't keep a lot of things secret for very long.
Be the reporter for me, Mr. Maynard. Where would you get the story here?
Well, there are at least 3 immediate sources that come to mind. The opposing counsel, one or the other of whom may, for machismo or other reasons, want me to know.
You think maybe Mr. Chesley would like you to know?
Well, I wouldn't want to put such a fine point on it as to put it precisely on Mr. Chesley, but it has been known to happen that after a complicated bit of litigation, a lawyer and a journalist might repair to a nearby watering hole, and in the course of discussing the recent wars and all the matters that went on, certain details that might not previously have been disclosed may emerge within the ballpark. That is to say,
the ballpark of between 5.5 and 6.5.
It wasn't 5.5 and it wasn't 6.5. That's exactly right.
Mr. Chesley, the fact is you have an enormous self-interest in having the amount of this judgment come out, don't you?
No question I have a self-interest, but I have kept them confidential in the past, and I'll continue to, because it jeopardizes my client's right to the recovery. And also, I have been involved in which sanctions can be imposed in various courts for releasing confidentiality. I will
So you would never tell?
I would not.
Mr. Cochette, you laugh.
I do laugh. I mean, that's all nonsense. Of course that's going to happen. It's going to happen in the watering hole, but it's not going to be between 6.5 and 5.5. It's going to be the answer is 6. That's what's going to happen.
Could be.
And it's going to happen.
I'm allowing for a
and if
certain
it
amount of
doesn't happen
latitude.
quickly over one scotch and water, he's going to leave that lawyer and he's going to go talk to the clerk of the court. And he's going to talk to the clerk that sealed that record. He's going to take that clerk, and as Bob points out, there's 100 voices that are going to talk about that.
Mr. Minter, would you consider talking to Judge Marriage?
No. No. The one place you do not go for the inside story is to the judge who tried the case. Unless, of course, you know things about that judge that you shouldn't know. And that happens.
And you don't know anything like that about him.
Nothing that I would be prepared to disclose here at any rate.
Justice Scalia, we have been through a lawyer's story here in an exercise that was meant to explore truth and ethics. We haven't heard a whole lot of truth, and we haven't heard a whole lot of ethics. Now, let me ask you, is this system that we're playing with here one that simply puts lawyers into roles that other people couldn't stand, that would be immoral for a regular citizen?
Are they put into roles? Of course they're put into roles. That's a very good word for what the common law adversary trial is. That is a play. Other systems don't work that way. In the civil law system, you do not have the three unities, that the whole thing takes place on one day. You'll have a civil case investigated by an investigating judge over months, and he'll hear one witness one day and another witness another day and so forth. We do it all as a drama. And the lawyers for both sides do play roles. That's the system we had. It's the system we've had for hundreds of years. I think by and large it works well. What we've been talking about today are largely questions at the margin. I think you can make any system look bad if you pick a particular hypothetical. By and large, I think it does work to have each side take the best shot at presenting the truth in favor of that side's case and let the jury decide between the two.
But the truth is a funny concept here, isn't it?
That's true, but consider the alternative. What do? Do you put the witness on the stand and let the lawyer ask as broad and unskilled a question as, tell me everything relevant about this case. Tell me whether you were negligent. How else do you run a system? The only alternative is to go to the inquisitorial system and have an investigating judge. And then you're going to win or lose depending on how good a judge you happen to have gotten. At least when you pick your lawyer, you know that if he's bad, it's your fault.
Mr. Neal, the expression on your face speaks volumes.
I don't want to be put in a position that I ever said that I'm out for the truth. The adversary system is not a system calculated to produce the truth.
What's it calculated to produce?
Justice, in the criminal sense. Let me
Justice
deal with
is different from truth.
No. Totally different from truth.
No, it's out to produce a verdict.
Well, let's say justice.
You
want to be...
Wind up this dispute, let's go on to the next dispute. Now, that may give a lot of us pause, but we have to remember the law of unintended consequences. And if we try to create a system that is more sensitive to truth and justice, it might be good in some ways, ours is not, but very bad in some ways, that ours does not have problems.
When lives and fortunes hang in the balance, when we see a society depend so completely on the courts to resolve our grievances, the ethics and attitudes of lawyers and judges are of vital importance to each of us. Is the courtroom truth, the whole truth, and nothing but the truth, so help us God? Are rights and ethics necessarily synonymous? Next week on Ethics in America, we look at the ethics of medical research. The struggle to treat a deadly disease can be a long and difficult process of help for some and harm for others. Join us next week for The Human Experiment.
This has been a production of Columbia University Seminars on Media and Society in association with WNET, New York. Columbia University Seminars on Media and Society is solely responsible for the content of this program. With additional support from Equicor Equitable HCA Corporation, the Good Listening Employee Benefits Company.
Annenberg Media. For information about this and other Annenberg Media programs, call 1-800-LEARNER and visit us at www.learner.org.